Hello everyone, my name is Kumar, Akashanand, legal intern at LEXIS and Company. Let us see one case, Workmen of MotipurSugar factory versus MotipurSugar factory, 1965. The fact of this case was, there was a gross row in the factory by the workers. Respondent issued general notice as well as notice individually to each worker notifying that such, unless he record his willingness to discharge his duties faithfully and diligently so as to give minimum certain output, he will no longer be employed, and he must record his willingness to allow by a certain date and time specified, following which they would be discharged without any further notice. Workmen failed to record their willingness. Respondent issued notice discharging their services. Respondent held no inquiry required by the standing order. A general strike followed, resulting in the joint application by both the parties to the government, and the government referred the issue to the tribunal. Now, the issue before the tribunal was whether the discharge of workmen was justified. Tribunal concluded that there was go-slow during the period of discharge was justified. Now this question comes to the Supreme Court by special leave petition, and it was contended that all the tribunal concerned was to decide whether the discharge of workmen for not giving an undertaking was justified or not, and it was no part of the duty of the tribunal to decide whether there was go-slow which would justify the order of the discharge. There was no inquiry held by the respondent. Now the issue was that whether the discharge was justified. Court held that the two notice has to be read together. If the discharge was being made on account of the failure to give understanding, the real reason for the discharge was the workman had been guilty of go-slow. On question of whether there was no inquiry held, it is true that the notice was not headed as a charge, and it did not specify that any inquiry would follow, which is the usual procedure when a formal charge is given. There could be no doubt that the workmen concerned knew what was charged against them, which was really responsible for their discharge. It is well known certain principle of decision that when an employee has failed to make an inquiry before dismissal or discharging a workman, it is open to him to justify the action before the tribunal. So the decision of the tribunal was held correct. Thank you. If you have any doubt, please mention in the comment below.